I don't see Evelyn.
Evelyn. Evelyn, your camera might be off.
Okay.
Oh, there she is. All right. Great. I think your camera's not on.
I turned it off. Here we are.
Oh, there you go.
Yeah, okay.
Great.
And you can hear me. Okay.
Yes. Yeah.
Okay, great.
So my name is Jordan Glasgow, and I am the 8th Circuit Governor for the ABA Law Student Division, and in my position, I represent the needs and interests of students in the Midwest, specifically Kansas, Iowa, Missouri, Nebraska, North Dakota, South Dakota, and Minnesota. In my position, one of the things we focus on is public interest, so I'm very excited to be a part of this webinar today, and I can touch on a little bit of the public interest things that we're doing at the national level, but I specifically wanted to talk about public interest at the 8th Circuit level, because that's where most students will come across involvement with the ABA is within your own law school. And so joining us today is Adrian Petrescu. Is that how you say your last name?
That's very good. You sound like a Romanian.
Oh, great. I'm glad. And he is my Lieutenant Governor of Public Interest, and he has a resume beyond compare. So I will turn over the floor to him. So Adrian, if you want to give a quick introduction of yourself and then introduce our guests, that'd be great.
Oh, thank you, Jordan. Here I'm just a CL law school student at Creighton University, and as Jordan mentioned, a Lieutenant Governor for Law in the Public Interest. But I had the great benefit and pleasure to have two grand professors of mine accept this invitation to join us today in this webinar. And Professor Michael Fenner, James Colley, 1954 professor of constitutional law at Creighton University and past president of Nebraska State Bar Association, and Dean Patrick Borchers, director of the Vernon Institute of Conflict Resolution and professor of law at Creighton University, former dean and former law clerk for Justice Anthony Kennedy, as well as Evelyn McKnight, president of the Honor Reform Foundation. And welcome, everybody, and thank you so much for accepting our invitation today to discuss about issues in law in the public interest. Appreciate it.
Well, thank you, Adrian, for inviting us to do this.
Glad to be here.
Thank you.
And I am as well. Thank you for the invitation.
So I have here in front of me a long list of 40-some items that Harvard University Law School lists as being related to law in the public interest. And if you go through them, from AIDS and HIV through animal issues, arts, entertainment, bankruptcy, all the way to trust and estates, voting, women's issues, and so on, it pretty much covers the whole gamut of law. And so I guess my first question is, what does law in the public interest mean, and how far does this concept actually go?
I don't like those kinds of lists, and I would dispute the list. I think that every lawyer works in the public interest, whether you're a criminal defense attorney working night court, or whether you're a personal injury lawyer who is suing cigarette manufacturers, or whether you're general counsel for Patagonia, or whether you're an 8th Circuit Court of Appeals judge. We're all supposed to be working in the public interest. But I think kind of the kind of thing that gets talked about as in the public interest these days seems to me to be generally talk about low-paying jobs that are somehow public interest jobs, like the county prosecutor or the county's public defender, or a legal services lawyer, a lawyer who opens a little shop in a poverty-stricken neighborhood, or a lawyer who works for the WCA dealing with violence against women, or whether you're a law professor, an underpaid law professor, by the way. But I think that we're all working in the public interest.
So that's a misnomer that we often use, and we should actually look at it in a different way.
I think that when we use that term generally these days, we're talking about something other than just public interest, which I think is a much broader category. and frankly, more and more these days, working in the public interest seems to mean to any particular individual doing work advocating for an issue that I agree with.
Mm-hmm. So if two corporate attorneys are engaged in a contract dispute,
that it's in the public interest to get that contract dispute resolved so that the parties involved can all get back to work. In Bush v. Gore, the court spoke and the rule of law prevailed and we all went back to work, and the tanks weren't rolled out.
mm-hmm.
Nobody was beat up in a bar fight, as far as I know. It's all in the public interest, whether you're a lawyer who's the president of the United States or a lawyer who's on the city council for the city of Kansas City. We're all supposed to be doing that.
Thank you. I'm really happy to hear that. It was Dean Borges. I took an international arbitration class with you, and I'm taking conflict of laws as we speak. I wonder if you could add to this from an arbitration or more generally alternative dispute resolution perspective.
Well, no, I think I agree with a lot of what Mike said, and I do think that one of the things that one of the skill sets that lawyers need to acquire is to be able to advocate for their clients in a lot of different forums than, say, when I went to law school. Because when I graduated from law school in the dark ages, litigation was pretty much all we talked about. But now you see lawyers very successfully resolving disputes in mediation with the help of mediators, going to arbitration, although I think the Supreme Court, frankly, has gone kind of overboard on arbitration and, frankly, taken it as an excuse to make certain kinds of disputes beyond the reach of any reasonable resolution. So I do think that every lawyer needs to consider the public interest whenever they're dealing with a case. Some of my favorite cases from practice, frankly, were very low-stakes disputes where I handled them pro bono. So I do think that everybody in the bar, whether you're working in a $160,000 Wall Street job or whether you're in the Douglas County Public Defender's Office, has got the same sort of moral obligation to think about those sorts of things. When I was dean, one of my proudest accomplishments was that we started a loan repayment assistance fund with some very generous grants, because frankly some of the jobs that students are attracted to just don't make a lot of economic sense when you consider law school debt. So I think that's something the law schools have to confront, and I think they've been confronting it, but I think we need to do more.
Wow, that sounds amazing. Jordan, you had a number of questions about a national loan repayment program for law in the public interest. You have some questions on that?
Sure. So at the ABA, we are working right now on campaigning to save the Public Service Loan Forgiveness Program, which is currently being discussed to be either capped at $57,000 or completely eliminated. And so I guess one of my questions is, how do you think that will impact the access to justice barrier if public service loan forgiveness were to be completely eliminated?
Well, I think it will make a bad situation worse. Even Creighton in Nebraska is by far the largest private provider of free legal services. But even between us, the University of Nebraska, Appleseed, I'm missing somebody else. We all had a summit a few years ago and concluded that we were probably only getting to 10 or 15% of the people who needed civil law assistance who couldn't afford to get it. And one of the things I always challenge my students with is I think about what you're going to bill when you get out or what you would like to bill, and now think about how long you could afford yourself. And so I think that would be most unfortunate. There actually has been, and I advocated for it as dean, there is a state program in Nebraska. It's very modest, but frankly, from a standpoint of people's survival and well-being, in many cases, access to legal services is as or more essential than access to medical services.
Right.
You often hear, Jordan, that there are too many lawyers, and as Pat kind of touched on, it's really not true that there are too many lawyers. What's true is that there aren't enough lawyers in some places. There aren't enough lawyers to service the poor. There aren't enough lawyers in rural practice in small towns. And the lawyer in a small rural town is a very important person. The minute you show up in that town, you become a player in that town, and the minute you leave, the town dries up a little bit. One of the things that we do in Nebraska, we have a rural practice initiative, and as lawyers, we all understand this. You can talk to people about what a wonderful thing a rural practice initiative is, or rural practice is, and you can talk to them until you're blue in the face, but they don't get it unless they can, the secret of all persuasion is to induce the other to persuade himself. So in Nebraska, we put these kids on a bus, and we take them on a bus tour to rural communities, and they get out there and they meet with the lawyers, they meet with the judges, they meet with whatever is the equivalent of the Chamber of Commerce, they meet with real estate agents, they see the hospital and the schools, and they see for themselves what a nice life they can have out there. And this has had a big impact on getting young lawyers to move into these rural communities and join someone's practice, or even in some cases set up a practice. But there just aren't enough lawyers in the right places.
Right, and absolutely, and I think that's an issue with many of our states in the 8th Circuit. Obviously, Missouri, even though it has 2 major metropolitan areas, St. Louis and Kansas City, still is majorly agricultural, and so I think that's an initiative that would be very beneficial to not only Nebraska, but all of our states in the 8th Circuit.
Well, they have a great program in South Dakota as well.
Right. Great.
And maybe in other states in the 8th Circuit, I'm not aware of.
Well, Iowa's part of it too, Mike. So both the Iowa schools and both the Nebraska schools are involved in it. So,
right. Is that something then that the American Bar Association as a whole, or maybe the law school division, can do through Jordan and her colleagues, governors in all the circuits, to actually get these best practices somehow generalized?
The Nebraska Bar got a grant from the American Bar Association to help fund this program, and it was a 1-year grant, and it has now run out. But one thing the American Bar Association can do is publicize these kinds of programs and get out the news to other states that they really work. And another thing they can do is to continue to give grants to help states set up these kinds of initiatives. And so much of what we're trying to accomplish comes down to money. Trying to help students who want to be, say, the public defender in Jackson County in Kansas City, help them be able to afford that by relieving some of their debt, which gets back to your actual question. And we need a whole lot more of that. We need a whole lot more of that, of inventive ways to get the money to support these kinds of programs.
On this issue of money, let me get to Dr. McKnight, who unfortunately was a client of malpractice, medical malpractice, not legal malpractice. And from that story, she managed to turn the entirety of the story, a very sad story, around, and start a foundation that is intended to get folks who have somehow been the result of medical accidents, more than simply monetary damages. Dr. McKnight, if you could briefly tell the story, and what is this way of turning things around in that we as would-be attorneys would need to learn from a perspective that eventually mirrors what Professor Borchers was saying in terms of mediation, but a certain particular type of mediation.
Okay, well, thank you, Adrian, and thank you for inviting me today. Let me tell you a little bit about my story, how I got pushed into this advocacy work. In 2002, I was recovering from breast cancer when I got a letter from Nebraska Health and Human Services saying, "Dear sir or madam, you've been potentially exposed to hepatitis C, hepatitis B, and HIV through unsafe practices by your health care provider. Please come to our facility to be tested." Ultimately, I was not the only one. 650 people in our small Nebraska town received this letter. After testing, we found that there were 99 of us who had contracted hepatitis C at the oncology clinic. What happened was the nurse drew our blood and then switched the needle on the syringe, but used that same syringe to access a large saline bag to draw back saline to flush our ports. This happened repeatedly throughout the day, and that's how the hepatitis C virus got into the saline bag and then into all of us. So 99 cases of hepatitis C, 89 malpractice lawsuits in our small town. We have one judge. It would have flooded the dockets for years. So all but one settled through mediation. I am married to a family physician, and I am a healthcare provider as well. I'm an audiologist. So we were in a bit of a unique position to look at this whole process and think about not only ourselves, but our entire community, our patients, our neighbors, our friends. And we reviewed all of the depositions, and together with our wonderful two attorneys, drew up an action plan to remediate the malpractice. It was very egregious malpractice. Lots of people at lots of levels knew what was going on, but failed to act for one reason or another. Some of those reasons they felt they were justified, but regardless, there was lots of opportunities to stop this, and it did not happen. So we came up with an action plan of 20 steps that we believe the defendants needed to implement, and by the defendants, I mean the doctor had absconded to his native Pakistan, so he was no longer in the community. The nurse had, by the time I went to mediation, had voluntarily surrendered her license. So it was actually the hospital that needed to implement this action plan. So we drew up this action plan of 20 steps. When we went to mediation, we brought this with us and said, we aren't going to settle unless you agree to these things. The defendant lawyer just initially laughed at this and, no, this is crazy. But they really didn't want this, very sick doctor's wife to go to jury trial. So they had a lot of motivation to settle, and so after 9 hours of intense mediation, they did agree to the action plan. Unfortunately, this was all new to us, and we didn't understand the necessity of really having some safeguards built into this action plan. So we didn't really hammer out how they would show that they had completed this action plan. So they did initially, begin to implement the steps, but I had I joined with a malpractice attorney, not my attorney, but another one in the community. And wrote a book about the outbreak, you know, from the patient's perspective, from the medical perspective, and from the legal perspective. It had not come to press. It had not been published yet. It was in the hands of a vetting lawyer when the hospital got a contraband copy of it and sued us, sued for a temporary injunction against publication of the book, a permanent injunction against publication of the book, and then also for libel. This was before the book came into print. So that litigation slowed us down considerably. Ultimately, that lawsuit was dropped. The book did go to publication. 3 years later, we felt that they had, in fact, implemented all of those steps of the action plan. So we are championing this model of mediation. We call it the Nebraska Malpractice Remediation Model. Before I get into that, let me tell you something else. This is a new concept. It is not completely out-of-the-box thinking. The University of Michigan Health Systems instituted a mediation model in 2001 that required an explanation of what happened. Just the defendants have to say, here's what happened. They did not have to show that they corrected it. This was in 2001. With just that modest element in place, their number of malpractice suits have significantly declined. Now, I'm not a statistician, and I can't tell you if it was cause and effect, but that's what happened. So I believe that if we go a few steps further and require healthcare providers to not only say what happened, but to develop an action plan and then prove that they have completed the action plan, I think that healthcare would be even safer.
So safety checklists and compliance verification mechanism. And we have areas in the law where we have checklists and compliance mechanisms. Is it feasible to consider that this can be brought into the medical malpractice area as well?
Oh, sure. I think this is a terrific example of advocacy in the public interest. You were not just advocating to get money. You were advocating to change the system so that this wouldn't happen to anyone else. And that's quite possible and ought to be done more. And you're to be congratulated for what you did.
Thank you, thank you.
I'm going to cry if I go on.
But is there something that we can do to actually affect change further, to the same way as we were thinking a minute before with tours in Nebraska, Iowa, Missouri, and so on, to verify law in the public interest in rural areas, to do the same and raise this on the agenda of, say, the American Bar Association, inclusive as to what we learned, so that, for example, alternative dispute resolution, something else that Creighton is very strong in, becomes a norm in our educating our would-be young attorneys.
Pat would be the one to talk about the alternative dispute resolution question and whether you can bring this into that, but surely you can.
No, I think that, well, first of all, I do remember the case. It was a very sad one, and it broke not long after I became dean at Creighton. But I think it does show. I think it does show the power of other modes of dispute resolution and thinking about things in an entirely win-loss mode, because it's clear to me that the mediation in this case was a net benefit to society. It's not only that the victims got to tell their story, and a lot of times really that's what they want as much as anything else. And unfortunately, sometimes I think we lawyers get boxed into thinking about winning and losing and how much money and so on, and yes, those are important things, and sometimes those are the only thing in cases. But in this case, clearly, it went well beyond that. In fact, I remember very well the doctor fleeing to Pakistan. It's the one and only time I've ever been quoted by a Pakistani newspaper about the case. So I think that's an excellent example of the power of alternative dispute resolution, and frankly, I think we do our students a great disservice if we don't try to talk about those sorts of things with them.
I wonder if I could, we should probably end in a more positive note. I'm really sorry, but I think we should.
Well, but I think that was a very positive note.
Oh, absolutely. No, agreed. But it's so saddening that I want to twist this around a little bit and ask everybody to what, in 5 or 10 years, to what do you think we, as we will graduate soon and take on this duty to society, in an ideal world, what should we be doing ourselves? What responsibilities should we have? And what great changes, positive changes should we be looking forward to?
Well, to repeat a theme, we've got to figure out a way to be able to educate people so that their college loans and their law school loans don't add up to something that disables them from taking low-wage jobs in rural America, or in a public defender or a prosecutor's office. It's just horrible that so many people who want to do that kind of thing can't afford to do it.
Thank you.
I think it's just a matter. I think the big changes are going to come from thinking about ways of resolving disputes in not entirely a somebody wins, somebody loses manner. I think that if we're really going to educate our students the right way, I think if lawyers are going to practice the right way, that yes, absolutely their client's interest has to be first, but they shouldn't confuse that entirely with an utterly adversarial way of looking at things. And I found the story about getting the changes at the hospital quite inspiring, and I know there are lots of other stories yet to be told and that will be told that will do the same or even better. So that's my positive note.
Thank you. Evelyn, in an ideal world, when I heard you speak at TEDx Omaha, the way you framed it then was that when you proposed that changes happen, and I have to sorry quote, the attorneys laughed at you. In an ideal world, how would we set up the system here so that there will be no attorneys left that when you contact them, on either side they are, would laugh at you, but rather they will tell you how to do it. They will teach you or teach everybody and know each other how to do it.
I think that we really need to institutionalize this method. I think that in Nebraska we have such a strong Nebraska Excess Liability Fund lobby, that is administered by the state of Nebraska, that if the state would adopt this method, that it could easily become the norm, at least in Nebraska. And I'm hoping that you folks can help me do that. How can, I'm going to turn around to you. How can we make this commonplace so that you don't have to be married to a physician to get these sorts of things done, that it's available to everyone and is actually part of the standard process?
Oh, thank you. Jordan,
well, one of the things Pat and I can do is, and law professors all over the country, law schools all over the country need to be teaching this so that the first time you tell the lawyer what you want to do, it won't seem strange.
Well, great. Thank you. And Jordan, with the risk that I will madden other people in the 8th Circuit, I will say never underestimate the power of Nebraska. Remember Meyer v. Nebraska. we gave the entire country and the entire world the power that parents have to teach their children a language or other skills that they so deem, and that survived to this date, and we hope that we will build more of such things in the future. I thank everybody for your time and for your kindness and your insights and your fabulous ideas and having taken the time from your busy schedule to help us out with these questions.
You know, Nebraskans also know how to hit a home run in the 9th inning to tie the game. So they
do. They do. Go Royals.
Yeah.
All right. Thanks so much. Honored to be on.
Thank you so much.
I appreciate it. Thank you, everybody.
All right.
All right. Well, thank you so much for participating. I know it was kind of short, but we really appreciate it, and I really loved hearing your story as well.
Thank you. Thank you.
All right. Have a great day.
You too. Bye-bye.
Bye.